Rick Black, and then followed by Rick Black is Douglas Franks.
Thanks, Ken, for your leadership in pulling this task force together and for everyone's participation today. What we're talking about here is exceptions. You have a good process. It should protect the vulnerable. However, we've seen hundreds and hundreds of times in the state of Florida, it does not. And now I lost my notes. My name's Rick Black. I'm the director of SEER. We're a 501c3 and we advocate for seniors and intellectually impaired adults targeted by the predatory legal community in POA, trust, and adult guardianship frauds. We have counseled and researched nearly 4,000 cases nationwide since we began our efforts in 2014. They generally follow a profile, isolate the victim, defame legitimate protectors, and liquidate the estate. Over 90% of the families who contact SEER, when we look at the records, they had legitimate advance directives in place that should have precluded the guardianship. Guardianship has a place, and SEER fully supports them when statutorily adjudicated with a bias to protect the proposed ward and their estate. Guardianship should also be avoided, as it is very risky and expensive to the ward and their loved ones. Every party paid from the estate of the ward works for the ward. Once under guardianship, then the ward is left powerless and often voiceless as their estate is drained. The initial order is a draconian action and too often yields inhumane treatment of the ward. Florida's guardianship system is broken, but statutes aren't the issue. The issue is that too often statutory obligations are ignored by the jurists and the attorneys. Testimony is not taken, material evidence is not considered, records are sealed, and the ward is denied the opportunity to speak or have independent counsel. Probate litigators lie, often engaging in a liar's choir, knowing they benefit financially by it. Why does this happen? Because the system financially rewards all court-appointed parties to create guardianships, and the system has little oversight. The equity court system, probate in Florida, is unwilling to prosecute its worst offenders, the litigators. In a lack of oversight and money for the taking, the criminal element flourishes. Estate trafficking, Medicaid, and medical facility risk mitigation are the main frauds. Litigators know almost anything goes in guardianship proceedings. The appeal process seldom yields redress. No probate jurist has ever been reprimanded by the Florida Judicial Commission Qualifications Commission for poor judgment on the bench. The Florida State Bar has not reprimanded or disbarred a single attorney for lying or manipulating a probate court proceeding to exploit a client as long as a judge approved it. SEER proposes a carrot and stick. Each proposed ward, not after the order is signed, should have free counsel. That should be provided by the federal government or the state so that these individuals are protected before their rights are removed. And there should be an adoption of a one-strike, you're out. When a litigator lies to benefit financially at the expense of a vulnerable adult, they should be disbarred and immediately all funds from the estate returned. Thank you for your efforts. You have a big job ahead of you.
Thank you, Mr. Black.